thank you for your patience this morning, especially to the Senate authors. We apologize for the delay. It's just the nature of the season, but we definitely want to get our business out of the way and get these bills rolling. Just for members of the committee, on the suggestion of the author, we're going to hold Senate Bill 343 that by Senator Schaefer, working out an issue. Same thing with Senator Douglas's bill that was on the original agenda but was taken off. That's going to be probably taken up next week. Authors were made aware of that, so I'm looking for the number. I don't have the agenda. No, that is Senator Staten's bill, which we will take up today. Let's begin with Senate Bill 371. Senator Calzert.
Simple bill. It's just to enable the GBI to investigate mortgage fraud. Current law gives very limited original jurisdiction to the GBI. They can investigate bombs and explosives, internet crimes against children, and identity theft issues. Those are the only criminal areas that they have original jurisdiction to conduct investigations. This will add to that list residential mortgage fraud to give the GBI the ability to create a mortgage fraud unit where they will investigate that type of activity and cooperate with local law enforcement in prosecuting mortgage fraud. It gives them the power to issue subpoenas with the consent of the Attorney General's office. This should be very helpful in multi-jurisdictional investigations spanning more than one county. It's difficult for local district attorneys just to, they can subpoena within their county, but you got mortgage lenders that are lending in multiple counties, and this would be a good tool for the GBI to do with the consent of the Attorney General. It passed the Senate 52-0, broad bipartisan support for this bill. It's just a relatively finite grant of power to the GBI to investigate this type of activity and cooperate with local law enforcement in the prosecution of it. I think GBI is here today also. They could answer questions. I'm willing to answer anything, and there's some folks from the mortgage industry that I don't know if they're signed up, but they can surely answer any questions that you may have.
Thank you, Senator Calzert. Questions for the author, Mr. Levitas?
Thank you, Mr. Chairman. And you said it passed 50 to nothing, is that right?
52 to nothing.
50. So that did a little bit better than your HR 178 did yesterday, didn't it?
I didn't have that one dissenting vote this
time.
Yeah,
you did have that one dissenting vote.
As a matter of fact, that was Senator Fort, and he is a co-sponsor of this bill. So
he
I don't
is,
think
in
you have
fact.
to worry about that when it comes back over.
Well, that's interesting. So it does make me consider whether we might consider a motion on this bill. But in the meantime, there's nothing in the bill that requires them to set up this unit. It just gives more authority to GBI, doesn't it?
Exactly.
Okay. At the proper time, I'd like to be recognized for motion, Mr. Chairman.
Thank you. Representative Mangum. Yes, I know Mangum. I was trying to match up the flashing light and the seat location. I've managed to memorize the names. Thank you.
That's all good.
Oh, thank you.
Mr. Levitas wants to be recognized for a motion. He kind of beat me to it, and that's all I really wanted to do, except I did want to ask this. I did notice on line 38, such person may object to the subpoena on grounds that it fails to comply with this code section or upon constitution grounds. When it says this code section, objecting to the, I don't really see any grounds to object to the subpoena. What would be a typical ground that one would be able to object to a subpoena on? I want to say I strongly support your bill. I strongly think that we should give any and wide latitude to eliminating this ravage to our residential and other areas. But mortgage fraud. What are some of the grounds, if any, that would qualify for quashing a subpoena?
I think that's probably directed to make sure it's within the jurisdiction of the GBI, that it would be a residential mortgage fraud type activity that was being investigated in the documents related to that. But, there could be some grounds that it was unduly burdensome or troublesome to them, and a judge would then issue a ruling whether or not it was enforceable.
Thank you.
Sure.
Mr. Franklin.
Thank you, Mr. Chairman. On Section 3, I have a concern about any executive agency issuing a subpoena, whereas which we're doing in the subsection A, but whereas in subsection B, if the person doesn't obey the subpoena, then they apply to the Superior Court to compel compliance. Is there any reason why you didn't have the agency go to the Superior Court to request the subpoena, rather than just having an executive branch agency issue it themselves?
Well, I mean, the Attorney General's office is the executive branch you're talking about. I mean, that's
The GBI.
yeah.
Now
But they have to do this with the consent of the Attorney General, which is, of course, elected by the state to enforce laws such as this.
But since it's the Superior Court that's going to be enforcing it, why not just go to the Superior Court and have the Superior Court issue the subpoena directly?
Well, that just is one more hurdle you would have to do to go to court to have a subpoena issued. Ordinarily, you wouldn't need to get the court to issue that subpoena. In most criminal prosecutions, you would not. And this allows the GBI to directly issue the subpoena if it's consented to by the Attorney General's office, rather than have to jump through that extra hoop you're mentioning to go to court and have a subpoena issued.
And how long does that normally take, just to go before a judge and request a subpoena?
I don't have any idea.
Okay.
Mr. Levitas, you're recognized.
Actually, in light of Representative Mangum here, I was going to defer my motion to him. All right. In that case, I will move that we pass Senate Bill 371 LC 294169 SCS.
There's a motion of due pass of Senate Bill 371 by Representative Levitas, seconded by Representative Abrams. Are there any amendments? Mr. Franklin.
Thank you, Mr. Chairman. On line 31, I move that we delete the word issue and replace issue with request.
Mr. Franklin proposes an amendment on line 31, striking the word issue and replacing it with the word request. All in favor of the discussion on the amendment, Mr. Levitas?
And if I may, Mr. Chairman, I'd just like to be able to ask, GBI is here. Does GBI already have, if I may, Mr. Chairman, first, may I?
Sure.
Does GBI already have similar, I seem to remember the GBI having similar authority to do this in other cases. Is that correct?
Yes, this is the same language that's in our Internet Crimes Against Children legislation that y'all approved here. It's the same language that's in the other authority that we have to identity theft, and so that in bonds, so they're patterning that which y'all already approved. Because I know the issue came up with several years ago about making sure that we run it through the AG's office before it is issued.
What I seem to remember. Okay, thank you, Mr. Chairman.
Thank you. All in favor of the gentleman's amendment signify by saying aye.
Aye.
Opposed? The amendment fails. Any further amendment? Seeing none of the gentleman's motion of due pass of Senate Bill 371. All in favor say aye.
Aye.
Opposed? No. The ayes have it. Motion is adopted. Thank you, Senator Calzert. I'm sorry? Oh, yeah, thank you. Thank you very much.
Need your house sponsor.
Yeah, no, I'll take a look at it.
Senator Calzert, house sponsor.
Yeah.
Would you like to sponsor that? Sure.
Done. Thank you, Representative Levitas.
Used up all the time in the well this year.
That's efficiency. Senator Staten, thank you again. Thank you for your patience. This is Senate Bill 364. Senator Staten, welcome.
Thank you very much, Mr. Chairman, members of the committee. Thank you for your hard work on this Thursday morning. I am speaking to Senate Bill 364, and there is a committee substitute, LC 294389S. Just about anyone in this room who has driven south of Atlanta, perhaps going to Savannah or Florida, has driven through the Macon area. One of the things that you encounter as soon as you cross over into the 18th Senate District, my district, are billboards welcoming you to Middle Georgia and enticing motorists to turn off the interstate to visit various saunas.
Exit 146.
Yeah, well, there are many of them, unfortunately. In Bibb County, there are 25 massage parlors. They're commonly referred to. We have more per capita than any city in the United States of America, including Atlanta, including San Francisco. In my 6 years in the Georgia Senate, I have had more complaints, comments, emails, phone calls about this one issue than anything else, frankly. And so finally, this year, I began to look at this issue and to see what we might do at the state level with respect to the Georgia Code and to address this issue. And that has led me to Senate Bill 364. Let me just walk through the bill very quickly. It's actually fairly simple. One of the things that we've done in Section 1 is to broaden the definition the definition of entity to include owners and operators. Sometimes in the sting operations, the young women who are working in these places will be arrested. They will be the focus of prosecution. But the owners and operators of these facilities or businesses or whatever we wish to refer to them as are often not prosecuted. So we wanted to broaden this so that owners and operators of these businesses where illegal activity takes place can be prosecuted. The Section 2 and Section 3 and Section 4 have to do with the massage therapy board, or the board that licenses massage therapy. This board operates under the Secretary of State's office. And we have worked through some of the sections of the code that deal with their powers or what they are able to do in order, again, first of all, to broaden definitions to include entities, and by that we mean owners and operators, and to some degree broaden some of the things that they can deal with. And you'll see that particularly in Section 3 of the bill, lines 42 through 51, where there is some addition with respect to advertising the offering of massage therapy services combined with escort or dating services or adult entertainment, or employing unlicensed massage therapists to perform massage therapy. In Section 4 of the bill, this is where we have given the board a little bit more authority with respect to what they can do to prosecute these businesses or the individuals. And you will see that the board on Section 4, lines 59 and following, they may take any one or more of the following actions against a person or entity found by the board to have committed a violation of this chapter. And on page 3, line 61 and following, you see the options they will have, including reprimand, revoking or suspending licenses, administrative fines not to exceed $5,000, or assessing costs of the investigations, and so forth. There was a sting operation, by the way, just a few weeks ago. You may have read in the paper regarding 10 of these places in Macon, and I'm very grateful to the Secretary of State's office for attempting to help us with this issue. In Section 5, this is a very important piece of this legislation. Because of the Massage Therapy Practice Act, many local cities and counties have not enacted local ordinances to deal with these businesses. For example, in Macon-Bibb, if you go in to apply for a business license for a coffee shop or a massage parlor, it's exactly the same. And some attorneys have advised that because of the Massage Therapy Practice Act, they are unable to enact local ordinances. That is uneven around the state, let me go ahead and say. And we think they can. The Massage Therapy Practice Act is about individuals being licensed for a perfectly legitimate and legal occupation, whereas counties and cities are able to license businesses. And so, but we are making that clear in this bill, just so that excuse, if it is, or reason, can hopefully be taken care of, that any place of business on lines 74 and following where massage therapy for compensation is performed shall also be subject to regulation by local governing authorities. But we've tried not to cross that line over into the Massage Therapy Practice Act, where the individuals, legitimate individuals, are licensed, and we recognize that and don't want to cross that line. And then finally in Section 6, Mr. Chairman and members of the committee, This is where there are some increased penalties. These would be the penalties that would come after a DA has made the decision to charge and gone forward, and we have simply attempted here to offer a step-up penalty, whereas now it is primarily a misdemeanor, and a lot of times the women are frankly just arrested, pay a fine, and they're just moved to another location. This gives a step up, and again, hopefully with the opportunity to go after the individuals who are both the owners and operators of these businesses where illegal activity occurs. I'm sorry, I've tried to be as brief as I could be, Mr. Chairman, and I don't mean to just rush over some of this, but I'd be glad to answer questions. There are others here as well who may be able to help answer any questions that you may have. But we believe this is a measured and appropriate approach to dealing with this issue that's very important in my area of the state, and I think in others as well, and will go a long way by helping the board in their role by making sure cities and counties know that they can enact appropriate local ordinances regarding the businesses, and that there are increased penalties for law enforcement that give them a reason to prosecute, because right now it really is just a very minor slap on the wrist kind of thing.
Thank you, Senator. No, we appreciate the explanation. Just a quick question. I'm sure this it may have come up in the Senate, maybe it didn't, and I know Ms. Travis is the drafter of the legislation. I was just curious if any question came up with regard to the prohibition on advertising. Did any question come up regarding any sort of commercial free speech issue? Or
I don't recall that question actually coming up.
And it may be a non-issue. It sort of struck me as something that someone could raise, and it may have absolutely no foundation. But I just
and she may wish to speak to that if she has if she would like to or has an opinion. And she was very helpful, I want to say. Thanks in helping to draft and revise.
It just comes under the category of unintended consequences, and again, it may be a non-issue.
I think my view was because of the way it is advertised, the offering of massage therapy services combined with escort, because of the way the definitions are defined, I've assumed that we were okay. But Jill, do you have a comment on that? And that was in the code, current law.
Okay.
So.
Okay. You and me both. Mr. Levitas.
Thank you, Mr. Chairman. And I'm not either. I mean, obviously, commercial speech can be regulated in ways that ordinary speech couldn't. But this probably is a question for counsel rather than for the author. But if the author can answer it, that's fine too. On line 27, can you tell me what the difference is, or on 26 and 27, what's the difference between advertising massage therapy services or advertising the offering of massage therapy services? Well, why is that new language necessary? What does it do different?
I think that this is frankly to help law enforcement, because the law has been such in the past that you had to send an officer in undercover, and they actually had to go into a very embarrassing situation, which was uncomfortable. No one really wants to do that. So we put in the offering to try to give them the opportunity to go into these places without having to go quite as far. If someone offers this to you, you don't have to, without being more graphic.
Yeah. Well, when I was a prosecutor, I worked with those vice guys. Some guys minded it more than others. There are, but that's not really my question. No, I understand that you want to be able to get them for advertising. I don't care even if it's redundant. My only concern is, because I like the bill, is that if it means the same thing. And I don't understand the difference between advertise massage therapy services or advertise the offering. I mean, the court's going to be looking for what that means because they want to avoid, and the term is mere surplusage. And so I'm wondering whether, if it's not necessary, whether that's going to confuse the law, because you've already got in the law that they can't advertise massage therapy services, and I just wonder what a court might look to try and figure out what that means. I don't have a problem with that. That's a friendly comment on the bill, and I'm not asking to have it removed. I'm just pointing that out as a
Mr. Chairman, I would defer to the wisdom of counsel and the committee.
It may end up being, from a practical standpoint, duplicative, I would think, because it goes to advertising. What is advertising? As opposed to the scenario that the senator pointed out regarding,
right.
It's more of a personal act. It's more of a personal conduct as opposed to advertising.
Again, even if it said the same thing, Representative Abrams, I'm always interested in her insights on things, but that's just how I read it. I did have, if I may, Mr. Chairman, I did have just one other question. Again, not to this. Well, I'm sorry, I have two other quick questions. One is, the easier one is, this is, again, friendly question, but I'm going to tell you what I've run into around the General Assembly and other elements of government. There is sometimes an idea, and I don't understand it, I've never understood it, that there are quote-unquote too many felonies on the books. Conduct is either felonious or it's not, in my opinion. I want to point out to you, or at least give you my experience, that you may run into some issues with at least some members or others who may say, I have a problem with it being a felony. I don't on the third, but I'm just, again, because I've run into that on other bills, and I've just pointed that out. The one substantive question that I do have, I got a couple of emails from legitimate licensed massage therapists who felt that Section 5 was putting them back to where they were 30 years ago when their profession was not viewed as a profession. I heard you to say we didn't want to mess with the Massage Therapy Act, but wouldn't this still allow them to be licensed in the same way and under the same sort of scheme they were back in the 70s?
No. We have carefully, that's one of the reasons why there's a committee substitute. This is not the original language in the bill, and so this has been crafted very carefully to try to address that concern. There is a distinction here between the Massage Therapy Practice Act and the board that licenses individuals and counties and cities and their abilities to license businesses. And so we're trying to to be very careful there. And so we've actually a lot of the original language has been stricken because we don't want to create a problem there.
But a place like Spa Sidel, Bliss, places like that, they would not be covered by this, or they would be?
Well, they're like any other business. They have to get a business license, and so if a county or city has certain requirements for the number of parking places or the size of where you have sprinklers or lights or whatever, the codes and so forth, they would be subject to that as any other business. But the counties and cities cannot license the individuals who are legitimately engaged.
And I've never heard, by the way, any from those folks. I've never heard from any of the whatever you call them, spas. Any objection? I assume you haven't either.
No.
Okay. Thank you, Mr. Chairman.
Just to put a finer point on it, let's take the scenario of an individual who's licensed as a licensed massage therapist, but they work out of their home, assumedly in compliance with local ordinances, etc. Is that a place of business at that point?
I would assume.
Let me back up a second. I apologize for interrupting. I assume the contemplation is you're looking at any place of business, a commercial spa that we
has to be licensed.
Spa Sidel, Natural Body, whatever.
Right.
That's a place of business.
Correct.
Would someone, given that example, would an individual who is licensed under the state, who happens to have their business, you can call it a business, it's just their license, and they happen to not want to have the overhead of some sort of commercial space. They do they perform whatever their services in their basement, let's say. Does that end up being a place of business, and is that?
I am not an expert on how cities and counties treat that particular type of business. The person that operates out of, let's just say a handyman that works out of his truck, doesn't have a storefront. I would assume if they are a business, they would have to still get a business license, even if they don't have a storefront. I don't know the answer to that. Maybe someone else would. But
I just want to clarify that the intent of that, and I'll look to the massage therapist in a second for some comment. I'm assuming the intent is to not bring that particular individual who happens to work out of their home under local regulation. Is that correct, or maybe it is? And I'm not editorializing on that. I'm just trying to get some clarity.
I do not know how that line is drawn for any individual who is operating a business, making money, advertising, but they don't have a physical location.
Would you mind if I defer to a second to the, I know one or more massage therapists are here that can give us a practical answer. Could you stand, please? Go ahead, sure. Just let us know who you are.
Yes, I'm Jane Johnson. I sit on the board of massage therapy.
Okay.
And whenever we go to get a business license, we normally take our state license with us, but we also have to, just like every other business does, we have to get approved by zoning. And some counties in Georgia and cities in Georgia do have zoning requirements for massage therapists. Some do allow home practices, and some counties don't allow home practices. So whichever the licensed massage therapist would have to abide by that local municipality regulation.
So it's a practical matter. You're living under that patchwork right now. Okay, thank you. That's helpful.
The Board of Massage does not regulate establishments, just the municipalities.
Very helpful. Thank you. Mr. Franklin.
Thank you, Mr. Chairman. I notice in the only place I see any illicit or the potential of illicit activity being addressed is in lines 43 and 44. And I'm wondering, it seems like we're doing a lot more regulating of the legitimate massage therapists when we're trying to go after the ones who call themselves massage therapists but are engaged in some illicit activity. And I'm just wondering, is there any definition of what is a massage therapist and what is involved in massage therapy that just by definition you could address what it is that we're trying to stop at the exit that the representative from ACWORK knows where it is.
I do quite a bit of business in Middle Georgia.
But rather than clamping a whole lot of regulation on legitimate healthcare providers, it seems like that's almost like a sledgehammer approach, when really what we need to do is tighten up to make sure by definition these illicit ones down in Middle Georgia don't fall within that definition, and we've got other code sections to deal with them.
Well, Representative Franklin, I would argue that in fact we are doing just that, just what you have suggested. We have very carefully gone into the code. It's not all duplicated here, obviously, at just a few places in order to help the board deal with people who are illegitimately putting themselves forward, using the phrase of the legitimate massage therapist for what is illegal activity. So I think we have tried to be very surgically precise at just a few key places in order to expand the board's ability to go after people who are abusing what is very, a legitimate healthcare occupation. So I would argue that that is exactly what we have done here. But we have worked with the board and the Secretary of State's office because I think they do want more ability under their abilities and what they're capable of doing. They want some help to be able to go after the people who are hijacking what is a legitimate occupation in our state. So I hope and I think the response I've gotten is that we're doing good and we are helping the legitimate folks by helping them weed out, so to speak, those who are not.
Just as a follow-up, because a concern really for me begins with on 46 and 47, where I can envision the scenario of a legitimate healthcare provider who, with the tough economic times, they're conducting their their massage therapy business in the basement, as the chairman mentioned, and people are deciding, I'm going to live with pain because I can't afford some therapy. And so the therapist business is down. They don't have money to go renew the license. And just because now they haven't renewed their license, now they're practicing without a current license, and if they do that 3 times, now they're a heinous felon. And we're not trying to get after them. We're trying to get out after these ones on the billboards in Middle Georgia, not the legitimate operators who, due to economic reasons, have not been able to renew their license.
The council reminds me that there are very defined terms, and some of which are not even duplicated in this bill. But with respect to the specific question, I mean, in my speaking with the Secretary of State's office and representatives of the board, I certainly don't think they're out to get people who are legitimately carrying out their occupation, or even someone that may have missed a deadline and not even be aware that their license expired last Friday. I don't think that's what they're attempting to do. They want to be able to go after those who are illegitimately doing this under the guise of massage, and that this is in fact something that will help them. So I think the board is and the Secretary of State's office, those who have the ability to go out and do these investigations, are well aware of the distinctions and the definitions, and certainly want this and able to go after the people who are committing the crimes.
Mr. Lunsford.
Thank you, Mr. Chairman. Senator Stanton, I appreciate you bringing the bill forward. I know it's embarrassing as a parent when you drive your kids down I-75. I try to find them a book to read about Macon.
Right.
And I get sick of seeing the signs, but I do have some concerns. If you look on page 2, starting with section 4, we're talking about the authority of the board,
Correct.
Massage Therapy Board, and I don't have a problem with that. But if you look at, you say any person or entity on line 57 believed to be acting in violation of this chapter, well, we've just now given the board the authority to act on people who are not members of the board, and we've given them more than we've given the judicial officer of our state by letting them impose a fine of up to $5,000 for a violation. But if they're convicted, they're actually paying a lesser fine if they're actually convicted in a court of law when you get into Section 6. So we've given our board more authority than we give in our courts, and they have the right to actually impose fines, including expenses related to investigation, before a person's ever convicted. And I just have a little problem with fining someone before they've actually been found guilty of anything by a board that had no authority over someone who wasn't a member of the board.
Well, the board has certain authorities now, and it might be that we would want to get a representative here from the Secretary of State's office to help us understand the distinction or the broadening of this.
Unless I'm reading it wrong, but I'm assuming that the people that are in violation of this chapter are not massage therapists, so they're not actually licensed by that board.
But they are violating the Practice Act by putting themselves forward as under the terminology and under all of the things that the board does license and regulate. And so they very much want the ability, when they go into these places and someone says, do you offer massage? Yes. Okay, fine. Where's your license? If you don't have one, do you want them just to turn out and walk out the door? I mean, this is I think a very helpful and necessary part of going after this illegal activity. But I'm certainly willing for council and others to engage on this, because I don't operate the board, or I'm not.
Yes, sir.
I do know they had an event recently, and maybe they could speak to that, where they did have a sting operation. I think they have certain authorities now.
They do. I looked them up. They can remove a member. They can have, for incompetence, neglect, dishonest conduct. They can remove their license and do other things, but they don't have the right to impose a $5,000 fine per occurrence prior to someone being found guilty by court of law. I'm just curious, Mr. Travis, is it normal that we would give the board the right to impose a fine of up to $5,000 for someone who wasn't found guilty in a court of law? That wasn't licensed by that board to begin with. Yes, ma'am. Yes, ma'am. Would love to hear from Michael.
Mr. Lindsay.
Actually, Representative Lunsford raised the question that I had in terms of the jurisdictional relation with the boards.
Thank you, Mr. Sessler.
Yeah, I had two questions. One was, and it was, I think it's a great catch by Chairman Lunsford. I mean, I think the state medical board, for example, and I see we've got MAG in the back. I don't know if they can speak to this. They've got some pretty strong powers with licensed physicians. I think they can apply administrative fines up to $5,000 for certain offenses for doctors. But I don't think someone that's holding themselves out to be a doctor that's not a physician falls under the jurisdiction of the board. I'm not clear that they are, and I don't know that attorneys under the bar would, if someone's holding themselves out as an attorney, could. I don't know, Mr. Chairman, if there'd be an appropriate time to address that. I think. So I would just ask that parenthetically: are boards and the other within the framework able to bring action administratively over folks they don't regulate?
We can. I mean, I think as a practical matter, Senator, I think that's an issue we would do well to go ahead and get vetted, to preserve the integrity of the bill. I think there's some discomfort on administrative powers and the extent of those versus what a court could do, even if, misdemeanors up to $1,000. That's it.
And Mr. Chairman, my concern's not those powers over licensed actors, because if they've been licensed for years, they've been getting compensation and a profit. They've been running a business for a while. I think them being subject makes sense. But if there's people that are pretenders, maybe they're better handled through criminal channels. I did have one other question, Mr. Chairman. Sure. When there are sting operations, and we talk about uncomfortable things in this room, what kind of things are stings brought on? Is it and does that's a sort of a part one of the question. The second part is the misdemeanor, high and aggravated, and felony, is that addressing underlying behavior that leads to a violation, or is that really focused just on you're dealing with licensure issues and operating without a license or violating license provisions? I'm assuming that the underlying behavior is handled somewhere else. Is that the case?
Yes, I mean often the charges are masturbation for hire or things like that, and I'm not a lawyer, so I don't know beyond that what some of them may be.
Adult entertainment kinds of things that they're not able to do.
I suppose.
You got solicitation. You got what Senator Staten mentioned. You've got various underage possibilities. I mean, that's just off the top of my head, and and then law enforcement can go and contradict me, please, if I'm wrong. I'll bet you, though, $1 that there is ultimately some sort of narcotics connection involved. I'll bet you $1 on that. So it
and Mr. Chairman, also there's sex trafficking that is going on. We've had examples of that. Were presented in our work in the Senate, and so this is a serious issue around our state. Unfortunately, it's very much in my district and in Middle Georgia, but I think that's we're trying to get at that. There are other areas of the law, other charges that can be used, and other penalties, but this has to do with the fact that these places put themselves forward, unfortunately, as places where you can go and get a massage, and so in that they are demeaning a very legitimate healthcare occupation in our state. And that is why I think there is so much of this related to that area of our code, because that has been often one of the ways to deal with them.
Ms. Abrams.
This returns to the earlier conversation raised by Mr. Levitas, and I can hold it if we want to continue. I don't know if there's anyone else.
Fire away.
And I would ask Ms. Travis, what I would see is the distinction, going back to the conversation on line 26 and 27, between advertise massage therapy services and advertise the offering. It may be a distinction without difference, but in my mind it would be if I have a massage therapy entity, and you're driving down the highway and you can see the sign, versus I have an adult entertainment facility, and if you come inside, I advertise that I can offer you these massage therapy services. So I would see the difference being that one, by its very nature, is the sign by its very nature is an advertisement, versus you also want to criminalize the fact that once you're inside, the offering of that service may not be part of the general nature of the business, but it may be something that they're offering. And I think you could probably capture the second with the first, but I would see it sort of as belt and suspenders and wouldn't see it as duplicative or causing any actual conflict.
It couldn't hurt. How about that? Mr. Levitas, last word.
Thank you, Mr. Chairman. I do have a couple of comments. I mean, first, the reality, to address Mr. Setzler's comments and what Senator Staten said. I mean, the reality is one of the reasons laws like this are important is because in the masturbation for hire, I mean, you're talking about vice officers literally had to have the massage therapist touch their penis in order for it to be a crime. And so this would prevent just that kind of circumstance. And I want to follow up.
Enforcement is very supportive of what we're trying to do.
Right. And, you know, I hate to follow up on but my colleague's erudite comments. As always, I'm going to snatch one of his ideas. Because when I looked at this again, one of the things that does concern me, it's not so much what the board can or cannot do, but it's this believed to standard to me is that's very scary to me, to be honest with you, because you're talking about if I think you did something wrong, I can take action against you. There's no proof, there's no standard in there, and I would suggest that may be, line 57, the word believed to. I would say that if you use language that you use down on lines 59 and 60, where they have found to have committed, but that's, that was my only concern. I mean, the penal code stuff doesn't bother me so much, but that standard was of concern.
Senator, here's what I'd like to do. You've heard the concerns. I share the concerns regarding the administrative powers that are established in here. I think we can get to where we need to be. I think we can easily strike consensus. We're going to meet again on Monday. What I'd like to do is hold it, come up with some consensus language that I think would provide some comfort level with regard to the powers, the administrative powers enunciated in the bill. We don't lose anything procedurally. Of course, we're not back in until Tuesday, but that way we can get a good, strong bill that we know that will hopefully be reviewed positively by the Rules Committee. So let's work together on that, and maybe we could talk tomorrow about that. And if you have any ideas, I'm all ears, and I'll do the same.
Okay, thank you.
And I'm sure we can arrive at a common sense place on that.
I appreciate your help.
Okay, yes, sir. Thank you. Senate Bill 173. Looking around, I don't see Senator Hamrick. I know this. Is there anyone from the Criminal Justice Coordinating Council here? Ma'am, would you mind coming forward? 173. If you could let us know who you are.
Okay. My name is Shawanda Reynolds Cobb, and I'm with the Criminal Justice Coordinating Council. Thank you, Mr. Chair and members of the committee. Basically, this is a department bill that does three things. One, currently, we have 24 council members, and what this would do is just put them in compliance so that they're receiving a daily allowance like other boards and commissions. Right now, the language says that they will be compensated in the same manner as the members of the General Assembly. We're currently paying them based on the daily allowance of other boards and commissions, but we just want to come into statutory compliance. Section 2 of the bill, the council has always administered grants and gifts by executive order, but there's nothing in the statute that allows us to do that. And the Attorney General's office made the recommendation that we make that change statutorily. And Section 3 is basically a technical correction. For many years, we were attached to the Office of Planning and Budget. Now we're attached to the Georgia Bureau of Investigation. And in one portion of the bill, it still says OPB rather than GBI.
Just a quick question on the expense piece. What does I see the per diem? We're aware of that for members of the General Assembly, obviously. But what would the difference be between that and for each day of actual? What's the difference in terms of what you're proposing on the expense piece?
I think right now the other the commissions of boards, I think it's like $103 max that they can receive.
Okay.
And we just want to make sure that we're in compliance with the other.
So that would actually be less than what the current than what the General Assembly per diem is.
Yes.
Okay. Questions, Ms. Abrams?
I'd just like to be recognized for a motion.
Okay. Any questions for Ms. Reynolds-Cobb? Seeing none, Ms. Abrams.
I'd like to move to pass LC 293652, Senate Bill 173.
Ms. Representative Abrams moves Senate Bill 173, LC 293652, do pass. Second by Mr. Mangum. Any amendments? Seeing none, any further discussion? Seeing none, Mr. Franklin?
If we could discuss a little bit more, what is the mileage rate there on line 18? We've strucken the mileage that members of the General Assembly would receive to just a nebulous rate.
When you say legal mileage rate, my understanding is that that's the IRS approved rate. Is that a correct statement?
That's correct.
Where would that be defined as by that definition?
The federal regulations.
No. In our code, how would we know that is what it refers to? Where have we defined it in the Georgia Code?
I'm not sure that it's actually defined in code because that changes. It's my understanding that there's a state and federal rate under guidelines that are issued, and so whatever that rate is, that's the rate of reimbursement.
Did you have something, Ms. Abrams? No. Okay. We had a motion. We had a second. See no amendments. Any further discussion? Seeing none, all in favor of the gentlelady's motion signify by saying aye. Aye. Opposed? No. The ayes have it, and the motion is adopted. Thank you very much for filling in. We appreciate it. Members of the committee, thank you for being here. We are going to meet on Monday, probably 9:30, 10 o'clock. Not tomorrow. We are not meeting tomorrow, but we will meet on Monday. Again, around 9:30, 10 o'clock. Agenda will be forthcoming. Thank you for being here today. We're adjourned.